just while he's doing that. So I'm Lorna Johnston. I'm the Executive Director of the Standards Commission. And as David said, I'm joined by my colleague Richard today. Richard's the case manager, our case manager. I'm hoping that to start with a bit of a positive message, which is that we were quite keen to host this seminar or to run the seminar, not because we're upholding loads of complaints about the way councillors are interacting with members of the public or constituents. It's not because of that. It's because we really want. We're seeing far more inquiries from members of the public who are not really understanding what a councillor's role is and what the requirements under the code are. So we really wanted to run this seminar to try and give you tips on engaging with them in a way that is compatible with the code, and also just to kind of make it clear what you are expected to do under the code. And I'll come on to it, but one of the things that you're not expected to do is to respond to each and every email that you receive from a constituent or, all telephone calls, whatever. So I will come on to that, but hopefully this is more of a positive message rather than you can't do this, you can't do that. So so Brian, if you can move on to the next one, thanks. Yeah, so just wanted to start by I'm sure everybody's probably aware of this, but just start by running through the ethical standards framework in general. So there's two organisations, the Standards Commission and the Ethical Standards Commissioner, and people tend to get them confused for the obvious reason that the name is quite similar. So the Ethical Standards Commissioner is distinct and separate from the Standards Commission, and his role is to receive complaints about councillors and MSPs actually, and members of 12 public bodies. But for our purposes, he receives complaints about councillors, and it's responsibility to decide whether those complaints need to be investigated, and if so, to undertake the investigation. The Ethical Standards Commissioner will then, when his investigation concludes, refer the matter to the Standards Commission, and it's our role to make the final decision on the complaint. But we see a sort of more important role even than that is our role in promoting the ethical standards framework, promoting high standards of conduct, and promoting the code, and try to help people understand the code and adhere to it. So we see that as a really important part of our role. So Brian, if you can move to the next one, thank you. Yeah. So as I said, if the Ethical Standards Commissioner has investigated a complaint and he refers it to the Standards Commission, we have three options available to us, and that's to hold a hearing, to direct further investigation, or to do neither, which essentially means taking no action, no further action will be taken on the complaint. If we decide to hold a hearing, it's to determine whether a breach of the Code of Conduct has occurred, and if so, to determine the sanction to be applied. And our governing legislation requires us to impose a sanction if a breach of the code is upheld at a hearing. The hearings are held by three members. It's a panel, the hearing panel's 3 members of the Standards Commission. We usually hold them in public, and it is a bit of a formal process, a bit like a court. The sanctions available for a breach of the code are to censure the respondent, to suspend them, and that can be a full or partial suspension for up to a year, or the ultimate one is disqualification. The good news is I've been in post for I think 9.5 years, and we've only actually disqualified one councillor, so that would be really, really unusual. And that particular councillor had been before us, I think, 3 different times, so there was a reason for the disqualification. Hopefully that's not a scary point, but if you can move on to the next one, please, Brian. So I thought we'd just cover here the Code of Conduct, but only really the parts that apply to when you're engaging with members of the public. The first thing to point out, and I'm sure everybody's aware of this, is that it is your personal responsibility to adhere to the Code of Conduct. You know, we would always encourage you to seek advice if you're unsure about a provision, and you can ask the monitoring officer, you can ask us, you can get in contact with Richard or I at any stage, but ultimately it is your personal responsibility to make sure you're abiding with the code. The code, and I'll come on to this in a bit more detail about when the code applies. So it applies when you're acting as a councillor, when you've identified yourself as a councillor, when you could reasonably be perceived as acting as a councillor, and I'll come on to that in a little bit more detail in a second. The code is not intended to prevent you from expressing views or making political comments. It just requires you to do so in a way that's compatible with the code, and that would be being respectful, not breaching confidentiality, etc. The code outlines the key principles of public life, and I'm going to list those quickly, if you just bear with me. So duty, selflessness, integrity, objectivity, accountability and stewardship, openness, honesty, leadership and respect. And this is something that I think members of the public don't always appreciate, but a breach of one of the key principles in itself is not a breach of the code. So if, for example, a member of the public sent a complaint to the Ethical Standards Commissioner saying, I don't feel that this local councillor has been honest about whatever it is, he wouldn't be investigating that unless they've also alleged, I don't think they were honest because they didn't declare an interest. They own the pub next door to the person who's put in a licensing application, and they've been dishonest and said that they didn't, and they've not declared an interest. But honesty in itself, complaint about honesty in itself, wouldn't be investigated. It would have to be linked to the code. So if I can move to the next one. Sorry, Brian, can you move the slides on? Thank you. Okay, so moving on to the applicability of the code, I've put in just a few examples to try and explain when the code would apply. And again, this is work that we're going to be doing in the upcoming year to try and educate members of the public on this. But I thought it'd be helpful to just put in a few examples. So the first one I've got here is a councillor who's attending a family wedding and introduces himself as a councillor and then gets in a fight with another guest, and that is reported in the press. So the question would be, would the code apply in that situation? And I know I've said that the code would apply where someone identifies themselves as a councillor, but that is really subject to it also being reasonable that they would be perceived as acting as such. So in this scenario, even though they've been identified themselves as a councillor and they were later identified as a councillor, the code would not apply in the situation because this is very much something that's happening in their personal life. So it wouldn't apply in that situation. I'm happy, obviously, to answer questions and discuss that in the Q&A, if people have got points to make about that later on. But if I can move on to the next example, Brian, please. Yeah, so this is social media. So a councillor posts an offensive comment on Twitter or X, as it's now known. They've said that they weren't acting as a councillor at the time because they clearly state in their profile that all comments on that page were made in a personal and private capacity. So again, the question would be whether the code would apply. And I think the answer to this one is it would depend. It would depend on the individual facts and circumstances of the case. It would depend on whether they'd had the privacy settings, how they'd had the privacy settings. So if it was still open to members of the public to view, then it's likely that the code could well apply because we think it's reasonable for members of the public to consider, with knowledge that someone's a councillor, to consider that they're commenting on social media in that capacity, particularly if they're commenting on matters that could relate to politics, that could relate to the services provided by the council. It would also depend on who they were following and who they had as followers, whether they'd commented in previous on previous comments on the page about anything to do with the council. It would depend on whether they were using council equipment. I think generally, though, in most of the cases that we've had before us, we have held that the code does apply when someone's using social media. So it's just to be aware of that. So Brian, if we can move to the next one. Thank you. Yep, so another one here that a councillor mentions their role as an elected member during a parking dispute with a neighbour and indicates that they would report the neighbour to the council. So in that case, again, we would consider the code would be likely to apply. I think it's the mentioning of themselves as a councillor and mentioning how, that they could take action, sort of suggesting that they'd be taking action in that role. And that, I think, would probably tip it over into the code applying rather than being a private matter. So moving on, Brian, please. Okay, so moving on to the kind of how you would engage with constituents. So the first thing that we want to put, as I've said earlier, is that, you know, I think if you have any correspondence from a constituent, or a constituent comes in and is repeatedly asking you the same thing or for help, you do need to consider whether you have to respond. There's no requirement under the code for you to do so. The code only requires you to treat people with courtesy and respect, but that we wouldn't consider, and the Ethical Standards Commissioner would not consider a failure to respond to be a breach of the code, a failure to respond in itself to be a breach of the code. So we'll come on to talk about this in the question and answer session, whether you do experience people asking, you know, kind of people maybe not accepting what you're telling them, or maybe not accepting a council's decision and being very, very persistent. So I think that is a really important point to make, that you don't necessarily have to respond. So the Standards Commission's actually produced guidance for members of the public guidance that you can hand out to members of the public that helps you manage their expectations. It's called an Assisting Constituents card, and that outlines what you can and cannot do under the code. So Brian, if you could just move on. Yep. Thank you. So this is the Assisting Constituents card. As you can see from this, we would advise you to say to constituents or anybody who's seeking your help that you can help them by seeking information from the council on any matter that, you know, that they want to raise with the council. You can advise officers of their views and help them make their views known to officers. You can give them advice on procedures and how the council might handle whatever it is the matter before it. And you can also raise their concerns with the council about any services or decisions that they've made. But it's really helpful to let them know that you will not be able to overturn a council decision, that you cannot seek legal advice from the council on their behalf, or pass on legal advice that the council may have given you as a councillor, and that would be either external or internal legal advice. You can't necessarily guarantee that information they give you will be kept confidential and that you will not be sharing it with officers. And also you can't represent council employees. So if a council employee comes to you with an employment matter about the council, you wouldn't be able to help them in terms of the code. Okay, so just moving on. Oh, sorry, thanks. So obviously, as a councillor, you're in a position of trust, and members of the public may provide you with information that could reasonably be regarded as confidential. And I think if the status of any discussion is unclear, you should try and establish at the earliest possible opportunity whether any or some of the matters being discussed are to be treated as confidential. And it's the same with the other way around. You're receiving information from the council, and it's perfectly legitimate for the council to treat certain information as confidential. So it works the other way as well, that you wouldn't necessarily, you obviously can't disclose confidential information to constituents. And it's just to bear in mind that confidential information is not always marked as such. Like I said, it may be something that either the council or a member of the public has asked you to treat as confidential. It may be exempt information under the 1973 Local Government Act. It might be information under data protection that you know, personal data that you shouldn't really be releasing. It could be commercial or sensitive information, such as relating to a contract. It could be information disclosed in closed or private sections of meetings. Like I said, legal advice, and that would be either internal or external legal advice provided to you. And information about any ongoing investigation being undertaken by the Ethical Standards Commissioner. Okay, so I'm just checking where I am. Yeah. So you should also be aware of the provisions under data protection legislation. If you hold personal information, such as details from a constituent inquiry or their personal details, then you are required to register as a data controller, which I'm sure everybody has already. And you must only use that information for the purposes for which it was given, and that would be, for example, for assisting with the inquiry. And you must not use the information you've acquired as a councillor for political, election or campaigning purposes. You shouldn't share the information without consent of the person giving the information, but that doesn't mean that you're not entitled to share a constituent's information with council employees for the purpose of assisting with that inquiry or complaint. But you just can't use their personal data in a way that would go beyond their reasonable expectations. So if they've asked you for help in understanding where what the council is doing with maybe a housing matter, then obviously you can go and ask the council about that, but you couldn't then use their personal data to, I think of something else, but in a completely different way. That wouldn't be, consent wouldn't be given for that. And you shouldn't keep the information longer than you would need to. In terms of freedom of information, it's just something to bear in mind that the provision of information comes at a cost to the council in terms of both perhaps photocopying and sending it out, but also officers' time in collating it. So where possible, you shouldn't encourage members of the public to put in freedom of information requests if they could get that information just by normal means without making a formal freedom of information request. And you should be aware of any information you produce or receive could be subject to disclosure. So, for example, that might be an email exchange between you and an officer. You know, just be careful what you say. I think in a previous role I've had, it was a board member sent an email to an officer where they said they referred to somebody as a frequent flyer, and that ended up being disclosed and ended up being in the media. So just be careful of that. Okay, so moving on, Brian, thanks. Okay, so when you're engaging with officers on behalf of constituents, there's just a few things to point out here. And the first one is that you need to avoid becoming inappropriately involved in operational management. So that's, if a duty is delegated to an employee, then it's likely to be operational in nature. And so becoming inappropriately involved in operational management or even operational decision making can be a breach of the code. It can also damage your relationships with officers. So while you may want to represent the views of your constituents on an individual matter, you should be aware that in doing so, an employee could feel pressured by you into making a certain decision, or it could appear that you're being critical of aspects of their work. So it's just to be mindful of that. And with operational management, the inappropriate involvement, that can kind of be in two ways. It can be both on that kind of decision-making level, if you're, you know, asking for so much detail at a really, really detailed level, that could potentially be a sign of you becoming inappropriately involved, but also the amount of engagement. So if you're repeatedly asking officers, you're sending them, you know, 4 or 5 emails in a week about the exact same matter, you know, that could potentially be you crossing the line into inappropriate involvement, because obviously you won't know what the officer's workload is and whether they've got other priorities. So it's just to be aware of that and be careful of that. The code also says that you cannot undermine officers or raise concerns about the performance, conduct, or capability in public, and the in public part is obviously the key part about that. And so that would include undermining them in front of constituents or saying something about their conduct, performance, or capability. So that doesn't mean that you can't scrutinise the way they're delivering services. It just means that you've got to be very careful about not raising concerns about an individual identifiable officer's performance, conduct, or capability. So it's just to be mindful of that there's ways of saying, you know, I'm not sure about how this decision has been made, and I need more information on this, rather than going in and saying, I think this officer so-and-so has been really unfair in this decision. They've not undertaken their duties properly, blah, blah, blah. So it's just being careful about the word it. And the code also says that you mustn't take or seek to take unfair advantage of your position as a councillor in when you're dealing with employees. And again, that's just to bear in mind that you are in a position of power over employees, particularly more junior ones. So you should avoid asking them or directing them to do anything that could compromise them or prevent them from undertaking their duties properly and appropriately. And just be mindful of the fact that even if you're not specifically saying you must do this, sometimes the way that you've worded a query or an email or whatever may sort of infer that you're trying to get them to do, that you're trying to direct them to do it. So just be mindful and careful about that. Okay, Richard, I think I'm going to pass over to you at this stage.
Thanks, Lorna. Morning, everyone. We're going to now have a look at lobbying. Now, as a councillor, obviously, you will be approached by various types of people, and you'll be approached by those who are wishing to make their views known. And that's perfectly legitimate and should be encouraged, as the ability of people to do this is an essential part of the democratic process. But at your end, what you need to be careful to distinguish between is your representative role, and that's when you're dealing with constituent inquiries, any community engagement you're undertaking, and working with individuals and organisations to encourage participation and involvement. And then on the other hand, lobbying. And that's where you're approached by an individual or an organisation that's seeking to influence you for financial gain or advantage. And that's particularly those who are seeking to do business with the council. Now, if you're approached by a lobbyist, it's likely that they're seeking your involvement as someone in a position of influence. And whether that's part of a decision-making committee, your role in a committee, or otherwise. And it's important to recognise that there's a difference between lobbying on behalf of a commercial or a personal interest and lobbying for a policy change or a benefit that affects a group of people, the community, or an organisational sector. And you as a councillor should always consider what will benefit the council area as a whole and not just any narrow sectoral interest. In all situations, care is needed, and you should be guided by the code. And in particular, here's a few pointers to consider. Firstly, could anything you do or say be construed as you having been improperly influenced to take a particular stance on an issue? You should think about whether you're giving or could be perceived as giving preferential access to any one side of an argument. When you're seeking information on the progress of a case or of a particular matter, are you doing so in a factual way, or could you instead be perceived as making representations or lending your support to something? And lastly, are you reaching your own view in a matter, and that's after having heard all the relevant arguments and evidence, and not simply agreeing or complying with any view that's been expressed? Now, just briefly before I go on to the talking about quasi-judicial matters, if you choose to be an advocate for or against a particular cause, you'll forfeit your right to be a decision maker in regulatory or quasi-judicial decisions concerning that cause. And if you're approached by someone and you want to remain as a decision maker, you can listen to their views, but you must make it clear to them that you can't lend support or make a decision until the appropriate meeting when you've heard and considered all the relevant evidence. Next slide, please, Brian. Now, quasi-judicial and regulatory decision-making is quite a hot topic, something that causes a lot of issues and comes before us quite often. And when you're making these types of decisions, you must do so objectively and with an open mind. And your decision should be made in accordance with the law, the policies of your council, and based solely in the merits of the case. And you shouldn't represent or make decisions based on any private interest. It's almost inevitable that you'll be lobbied by a number of parties, both for and against issues that you're looking at. And paragraph 7.9 of the code makes it clear that if you wish to remain part of a decision-making process, you can't act as an advocate either for or against an application. If you do so, you're obliged in terms of paragraph 7.10 to declare an interest and leave the meeting room. And that would include leaving the media gallery or public gallery or any other space. Now, if you do want to make representations on behalf of someone, if that's in relation to a matter that's before a committee that you're a member of, you should advise the chair and your committee clerks at the earliest opportunity. You should ensure that your declaration of interest is recorded in the minutes of the meeting. And when you're making your representations, you should do so from the same place as any other member of the public would, and not from your usual committee seat. And you should only participate to the extent that your council's procedures and standing orders would allow any other individual to do so. If you're looking to make representations before a committee that you're not a member of, then you can only participate to the extent that your council's procedures would allow anyone else to do so. And once you've made your representations, you should retire to you should do what your council's policies say. So if that says you should retire to the public gallery, you should do to the same. And if you do that, you shouldn't do anything from there that could give rise to suspicion that you're trying to influence the decision. Lastly, just site visits. The code recognises that individual councils will have their own policies and procedures for site visits. You should follow those, and you shouldn't give any impression during a visit that you prejudge the matter prior to the decision making at the relevant committee. Next slide, please, Brian. We often get inquiries from both community councillors and elected members about issues that have arisen from community council meetings, and we've produced a card for councillors that they can take along to these community council meetings, which demonstrates what they can and can't do, and it's part of a expectation management process for community councillors. So I won't go through them all, but you can download that from our website, and I think it will be quite useful, because quite often community councillors feel that councillors can just wave a magic wand and do X, Y, and Z, and that is not usually the case. Next slide, please, Brian. So in addition to that community councillors note, you'll find a lot of other useful resources on our website. We have our main guidance document on the code, and that contains a lot of case examples and illustrations that should help you interpret the provisions of the code. We've also got advice notes on various topics, including some of the things that we've touched upon today, such as distinguishing between strategic and operational matters. Got one on bullying and harassment, freedom of expression, online meetings, one on social media. We've also got, as Lorna mentioned earlier, a guide to the code for members of the public, which again is part of expectation management, the assisting constituents card, and the one we just looked at, which was the attending community councils card. Next slide, please, Brian. I think we're going on to hear from you guys with any questions you might have about the presentation. So Brian, I think we'll maybe stop the recording there.